Hello, my name is Colleen Clark, and I am a county court judge in Arapahoe County, Colorado, in the 18th Judicial District. The county court civil docket is a very entertaining and interesting place. It primarily deals with pro se litigants. It has a limited jurisdiction. At the time of this recording, the statutory limit for the county court is $15,000 and under. There are no injunctions except for protection orders and assorted homeowners association matters. And there are no domestic cases, either involving litigation or involving title to real property. Rather, the bread and butter caseload of most county court civil dockets consists of contract and tort actions, landlord-tenant evictions, protection orders, and various homeowners association claims. But the granddaddy of them all, and the focus of this particular course, is debt collection, which includes credit card debt, consumer debt, and medical debt, among others. As with any case, the first thing a court needs to review is whether jurisdiction and venue are proper. The court will then determine whether the defendant was properly served. Service issues are far more common than you might imagine, so please do not overlook this step. In general, you'll look for a return of service that matches what the parties describe in the complaint. In other words, if the complaint says that the defendant is a 6-foot-tall male with blonde hair and the party in front of you is a 5'3" brown-haired female, it's pretty clear that the correct person was not served. Again, this happens more often than you think. After you have confirmed that jurisdiction, venue, and service are all proper, the next question is whether the defendant has filed an answer to the complaint. When a complaint is served on a defendant, the plaintiff is required to attach a summons and blank answer form. The summons contains a return date, which lets the defendant know that he or she needs to come to court to respond to the complaint. Typically, the return date on the summons is at least 14 days after the date the complaint was filed. If the defendant answers the complaint, you'll issue a mandatory mediation order to the parties. This is a standard order that requires the parties to sit down with a neutral third party to see if they can resolve their dispute without the need for a trial. I have provided a link to a mandatory mediation order with this course, or you can obtain a copy from one of your colleagues or your court administrator. It is important that you put a hard deadline on when the mediation must be completed. It is also important that you require the parties to file something with the court to let you know that mediation has been completed. If a party refuses to participate in mediation, you can dismiss the case or enter a default. Be cautious in doing so, however, and make sure that the failure to mediate was a willful violation of your mediation order. Once mediation has concluded, if the parties have not reached an agreement, set the case for trial. Most debt collection cases can be heard in a single afternoon if you have properly set expectations prior to the trial. You can accomplish this by issuing the parties a trial preparation order, which requires them to exchange witness lists, exhibits, and other types of information. Without a case management order, you can quickly find yourself managing the county court Kinko's office, with the parties asking you or your clerk to print exhibits, copy photos, and download materials onto your clerk's computer from their phones and iPads. In most cases, despite proper service, the defendant will fail to file an answer to the complaint. This can happen for any number of reasons. For example, they may have simply ignored the problem, or they know they are liable for the debt and they have no defense, or possibly they want to dispute the case but they are too poor to pay the answer fee. Although clerks can waive answer fees entirely if an individual files an informa pauperis motion, many defendants are unaware of this option. If the defendant fails to answer a properly served complaint, you must still make sure there is proof that the debt is owed. The plaintiff must provide valid evidence regarding the amount of debt. For example, assume that the plaintiff introduces evidence of a signature showing that the defendant agreed to be responsible for medical services provided at a hospital. Open and shut case, right? Wrong. Even signatures have become an issue in an age when many of us apply for credit cards online. There needs to be additional proof that you have the correct person connected to the debt and that the amount being claimed is legitimate. Just because the plaintiff says the account is real doesn't mean that it is. Of course, many debts are actual debts, and the reason the defendant failed to respond is they know they owe it. Once you have verified service, are provided valid proof of debt, you are provided the amount of the debt, and the defendant has failed to respond to the complaint, then you can enter a default judgment as needed. And yes, there are a significant number of default judgments in Colorado courts every day. After entering a default judgment, the court has one more task, determining the attorney's fees, which comprise a huge portion of all consumer debt. In general, the American rule is that each party pays for its own attorney regardless of outcome. In Britain, it is just the opposite, with losers paying the prevailing party's attorney's fees. There are two exceptions to the American rule. First, contracts can provide for an award of attorney's fees. Second, statutes can require that the prevailing party is entitled to an award of attorney's fees. At least in county court, the American rule is dead, and you will award the debtor attorney fees in most cases. Although you are required to award attorney's fees, the request still must be reasonable. And in general, the determination of reasonableness is a question of fact for the trial court, and one in which you have great discretion. Many courts have a standard fee award that can be granted without an affidavit. In Arapahoe County, it is $400. If an attorney seeks an amount above that figure, I require the attorney provide evidentiary support for his or her fee request. Again, thank you for watching this video. Although debt collection cases can seem rather routine at times, I think you will find that justice is best served when we hold every claim to the standard of proof required of all Colorado cases. I'd like to thank my colleagues in the 18th for their help with this script. Good luck on the bench.